let's again formally welcome Sir Sridhar. Yesterday it was a fantastic session. I really enjoyed it. So today I'm sure I'm looking forward to even more exciting session. Yeah, over to you, Professor.
Thank you, Professor Vivek. Today's session, yesterday we discussed about the taxonomy of privacy. So we basically looked at the different aspects of privacy. Some are very harmful. Like, for example, we discussed yesterday that surveillance could be very, very harmful. Secondary use can be very, very harmful. But some of these are moderate, right? So, for example, identification is very, very harmful. But things like, interrogation or for example, aggregation can be moderately harmful, and something may not be harmful at all, right? So, when there is a harm to an individual, then how should the individual be protected? So, if there is a violation of privacy and there is a harm, privacy harm, right? So, the privacy harm could be of various types. It can be reputational harm. Yesterday, we discussed about how, for example, distortion of facts about a particular person can actually spoil the reputation of the individual. Somebody, tweets that Professor Sridhar drinks a lot, then you will not have any much respect for me, even if I teach well, right? So there is a reputational harm, and that can stand throughout my life, right? So this is reputational harm. Some harms can be really financial in nature. For example, we talked about ransomware yesterday. So if you are blackmailed with a ransomware and you pay, for example, 1 lakh rupees so that your laptop is not compromised, then you have a financial loss. So there are various laws to an individual because of privacy violations, and there has to be a recourse, right? The recourse can only be provided. Of course, the recourse can be provided through mutual negotiation. Suppose, for example, if there is a problem with payment, it has happened a number of times. You go to some medical store or something like that, you purchase something, and then you pay through Paytm, right? Now, the Paytm says that the transaction did not go through. Okay, so you pay it again. So 2 times you have paid. Then you come home and find out that you have 2 messages from your bank, right? 2 times the amount of 1,000 rupees has been deducted. Where will you go, right? Whose mistake is it? It has actually happened to me, right? So I go to the Paytm, I put a complaint saying that, you said it did not go through, but it actually went through even in the first time. So 2 times the amount has been deducted. So please refund me 1,000 rupees. What will Paytm guy say? Paytm will say, it's not actually our problem, it is actually NPCI problem. So you go and contact NPCI. So you go and contact NPCI. NPCI will say, it's actually not our problem. There might have been some problem with the Wi-Fi access. So or the mobile access, you find out from your mobile service provider. I go to Airtel, who is my mobile service provider, who provided me with connectivity. I ask him, because of your connectivity was very poor, that I got this deducted 2 times. What will Airtel say? No, it is not actually our problem. It is actually Paytm's problem, because Paytm is the payment service provider. So I go in a loop, right? Finally, nothing gets resolved and 1,000 rupees is gone. It is in these cases that law and regulation helps to our rescue, right? So one possibility is, of course, 1,000 rupees is not much, and therefore I might not go to the court. But if I indeed go to the court and sue Paytm, if I know that Paytm has the culprit in this particular value chain, then you should actually sue them for $10 million, or 10 million rupees, or 1 crore or something like that, right? So it's not a question of suing, but it's a question of accountability, right? Accountability is enforced, can be enforced only by regulation and law, and therefore we'll discuss this in this particular section. So privacy, especially with respect to privacy, what are the different possibilities, right? So this is the timeline, and we have really gone through it quite a bit. So for example, there is an age-old Telegraph Act, which was enacted by the British, when we were British colony. This was enacted 1885, and of course some modifications have been made, but this particular Telegraph Act is mainly meant for privacy of the individuals who communicate through telegraph or telephonic equipment. So which means that, when you wiretapping, right? We said that we did not discuss it much in the yesterday's class. Wiretapping is very common. Today also they have people who are talking about this NSC wiretapping case, right? There is a case which is going on. So wiretapping is when, either the state or the private firms tap your telephone wire, and then listen to the conversation, which is happening over this. That is an invasion of privacy, right? It's in fact surveillance, right? Now, all these telephony activity are governed by our Telegraph Act. Right? All the telecommunication service providers have to abide by the Telegraph Act. So unless there is a very strong evidence that the wiretapping has to be in place, wiretapping cannot just be done either by the state without a warrant or by any private companies. Then we moved on to, so once internet came, the privacy breaches not only happened for the communication across the telecommunication lines, but also on the internet. And therefore, we enacted this Information Technology Act in 2000. It was amended in 2008 to include all computer-related offenses, right? If you are using a computer and computer-related resources, and then a crime happens using that method, then it is governed through the Information Technology Act. Then Aadhaar came into picture, and then there were a lot of issues with respect to Aadhaar. Yesterday, we discussed about the fact that biometrics, which are collected by UIDAI, is a very, very sensitive information. So if biometric gets leaked, then it is a severe invasion of privacy. In fact, in yesterday's class, all of you gave 10 for identity breach using biometrics data. So the Aadhaar Act came into picture in 2016 so that enough privacy provisions are provided in the Act for protecting your identity-related information, especially the biometric information. Right? Then in 2018, we thought that we should have an umbrella act. There are this Telegraph Act, which governs privacy using telecommunications, IT Act, which provides sort of privacy and security related aspects with respect to information technology and computer related offenses. Then there was this Aadhaar Act, which provided privacy protection against the use, against the improper use of biometric data appended to the Aadhaar number, and so on. So we had these bits and pieces. So we thought that we should have an umbrella bill which protects the data of individual natural citizens, natural persons. So we created this data protection bill in 2018. Now, at the same time, this was born because the world looked at the Cambridge Analytica scandal, as we discussed in yesterday's class, and then thought that all these internet companies, which are called as data fiduciaries, have to be governed and regulated for privacy protection of natural persons like you and me. Otherwise, they will go ahead and do whatever they want, right? This Cambridge Analytica scandal basically, manipulated people's opinion on electoral votes. Then we had this Edward Snowden's revelation of how the National Security Agency in the US was snooping on individual persons' personal information, and so on. So the European Union decided to create an umbrella act called General Data Protection Regulation in 2016. In fact, I had changed my WhatsApp image at that time, and then said that GDPR is it is ominous, because it has covered so many details. And the important thing was the privacy of the natural persons was the center theme of the General Data Protection Regulation. In fact, I thought that all the internet companies would be ruined if they don't adhere to the GDPR. Of course, internet companies are surviving, and we'll discuss a little bit more about that later on. So after the European Union enacted the General Data Protection Regulation, we created this data protection bill. So most of the clauses in the data protection bill are actually derived from the general data protection rule regulation, but with some modifications. Okay. The sad thing is that it's about 4 years now since the original data protection bill was created, and it is yet to be enacted in the parliament. Right. So unless it is enacted in the parliament, it cannot be considered as law. So we don't have a law yet on data protection and privacy. It is still pending before the parliament. Of course, we had a standing committee on information technology, which looked at the details of the data protection. In fact, the 2018 bill was called as personal data protection bill. Then the committees looked at it and said that it is no more personal because something else was added, and therefore personal was removed. So it is a data protection bill, but it is still to be enacted. So we'll go through some of the details of this data protection bill. Important. We'll also go through GDPR because that's the golden standard for privacy and data protection worldwide. Then we also had the Information Technology Act, some other rules, right? Rule in 2021, which has become a very, very controversial thing. We'll discuss a little bit about that. Now, this is just a snapshot of whatever is happening. Simultaneously, all the countries had enacted their own data protection privacy bills. However, the US is very different, right? The US looked at privacy. In fact, as I told you yesterday's class, Soloway wrote about this privacy taxonomy way back in 2006, right? Even in 1996, this Health Insurance Portability and Accountability Act was created in the US to protect the health information of the individuals. Health information, not any other information, health information. So this is a very specific act which governed the privacy of health information, because health is very, very, as we discussed yesterday, right? Health data is very, very sacrosanct, and it is known only to the patient and to the doctor. We discussed about breach of confidentiality, where a doctor can actually disseminate the information about the patients to outside, and it can cause serious privacy harm. So to protect against those kind of privacy harms, the US enacted the HIPAA, the Health Insurance Portability and Accountability Act, way back in 1986. Followed that with financial. There is an act for this called Sarbanes-Oxley Act, which protected the financial information of the individuals. But there is yet, as of now, as we speak, there is no umbrella data protection and privacy act or law in the US. Okay, unlike in the EU. EU has 22 or so member countries, and all of them adhere to this EU GDPR. Whereas, in fact, in the US, there is no omnibus, that is, an umbrella data protection bill or act as of now. Okay, so this is the history. Any questions? You can type in the chat box, and then Shyam will read it out. Any questions?
Dr. Shravani is asking about CCPA.
CCPA. It looks like a
I can enable her to talk, and then maybe she can probably.
Go ahead.
I'll do that. Give me 1 minute.
Yes, Dr. Shravani.
Hello, Professor.
Yeah. Go ahead.
Yeah, so it's a wonderful session yesterday also, and today also we are listening very good things. So I would like to know about, because HIPAA that you are talking about is for health.
Correct.
Right. So there is one more act or a law that had come across while working with some US government companies, that is California Consumer Privacy.
California Consumer Privacy Act. Yeah, you are correct. You are absolutely correct. See, what happens, I'll just discuss a little bit, right? Consumer protection is also very important, and some of the privacy invasions can also be handled through consumer protection laws and regulations, right? So California Consumer Protection Act provides certain kind of remedies for consumers if their information gets leaked or privacy harms are caused by the entities that are providing consumer related services. Now that is true, but it is not an umbrella bill, right? First of all, it is not a data protection bill. It is a consumer protection bill. So which means that it has to be closely linked to the consumer interest, right? There has to be some kind of a consumer interest related to that particular incident. The second thing is in the US, like in India, they have many states, right? 50 or so states. And like a federal system, in the US, there is an omnibus federal laws, but there are also states which can enact their own rules and regulations, right? So for example, you must have heard about this abortion bill, which was passed by the Supreme Court, right? So each and every state is creating their own abortion act. So that is possible in a federal system. India also it is possible, but India, some things are centrally governed. For example, privacy and data protection is a central subject, whereas education is both central as well as state. That's why there is an education act for each state, right? So in the US, the individual states can have their own acts, but as of now, of course, California has enacted something like a data protection act, but there is at the federal level, there is no uniform data protection privacy law which is governed across all states. Does that answer your question? It's very state specific. That particular Consumer Protection Act of California is valid only within the state of California. It's not valid outside. And that's also a consumer protection regulation. It's not privacy protection regulation. Okay, so we'll come back and discuss a little bit about it. Yeah.
Chetan has a question asking if there are any data scams that you are aware of recently in India.
Yeah, I'm going to discuss some cases. Yeah, we'll do.
Okay. So there's another question. Oh, sorry. Go on.
Yeah, we'll go through some of these things, and then probably we can stop in between and take questions. Sure. So, IT Act. So we'll not touch on the Telegraph Act because it is very outdated and it just is very narrow enough to just talk about wiretapping and things like that. So, but the Information Technology Act is an umbrella act for information technology related crimes. And we discussed, if you remember yesterday's session, we discussed about the first cyber case, which was filed way back in 2000, right? We also discussed that in this particular case, there is a whole case of appropriation of the credentials of Barbara Campa by Arif Khan in conducting this particular e-commerce transaction to the benefit of Arif Khan, right? So it is a very classic case of appropriation, if you remember the attributes that we discussed yesterday, and hence it is related to privacy of the individuals. Even though this particular Arif Khan case was registered under Indian Penal Code, it was not registered under Information Technology Act. It has to be noted that it also is a cause of privacy concern. Privacy is also included in this particular case, right? So since we have demonstrated this appropriation case, we will move forward and then we'll go through the next ones. So Section 66, basic of the Information Technology Act, basically talks about computer-related offense. If you just see here, computer, that is the definition here, computer-related. So I will not go into this. See, I'm not a lawyer, and I don't know how many of you are lawyers, but I have found out that law is like math. Okay, it has to be very precise, and it has to be such that nobody can understand. Right? If nobody can understand, then it becomes a law. So it's very difficult to explain law, right? So I'll just take you through some of the examples that will be easier. But anyway, so to just say Section 66C of the Information Technology Act basically addresses the fraudulent or dishonest use of electronic signature, password, or other unique identification features of any other person. So this basically, if you look at it very closely, it is closely related to appropriation case as we discussed before. So the Arif Khan case that we discussed about exactly comes under this particular class, because Arif Khan fraudulently or dishonestly made use of the credentials of Barbara Campa in order to conduct the electronic transaction, right? And for his or her benefit, and therefore it shall be punished for imprisonment, okay, according to Section 66C of the Information Technology Act. Section 66D of the Act discusses about punishment for cheating by using computer resource, cheats by personation. This is exactly what Arif Khan did, right? So he got the credentials of Barbara Campa, and he cheated Barbara Campa, by conducting the electronic transaction without she knowing about it, so that she would pay for the TV that he ordered, right? So this is a complete case of cheating by using computer resources, because he used computer and the internet in order to do this particular crime, right? So both section 66C and D will cover the Arif Khan case that we discussed in the yesterday's class. Okay, this is a very famous case. What happened was that there was a company called Joypulichem Chem.com. It's a chemical company, and Sandeep Varghese was the names are all changed, anonymized. Okay, so Sandeep Varghese was the IT staff who was maintaining all the IT resources of this particular company. There was some problem with him, and then he was dismissed, okay, by the director. So even though he was dismissed, he had access to all the credentials of the website. So what he did was, after he was dismissed, he went home and went to the website and defaced it. He defaced the website of jaypoluchem.com. He defaced it. And then he sent anonymous threatening mails, right, from hacked supplier accounts. He hacked the supplier accounts of this, and then he sent threatening emails to the director saying that, you owe me 1,000 crores, you owe me 500 crores, and things like that. If you don't pay, then I will go to the court, or I will, something threatening. All threatening mails he sent. Okay, so this is a very famous case known as Sandeep Varghese versus State of Kerala. Now, is this a privacy case? Right? It's definitely a computer-related offense, because he hacked into a computer system, he defaced the website, right? And then he also sent threatening emails. Okay. Now, does this come under any of the attributes that we discussed in yesterday's class? In yesterday's class, in the chat box, please. Is it related to surveillance? Is it related to secondary use? Is it related to aggregation? Is it related to interrogation? Is it related to intrusion? Is it related to a distortion of facts? Is it related to blackmail? Anything that you can see, Sean, in the chat box?
They are saying impersonation, offense, blackmail.
It's not impersonation. He's not okay. So if you say that he is impersonating a supplier, the hacked supplier, yes, it is impersonation of the supplier account. Yes. Any other thing?
There are many responses saying blackmail.
Blackmail. It's definitely a blackmail, because he is sending threatening emails, right? And therefore it's an intrusion for the director, right? And he defaced the website, right? And therefore there is a reputational harm, right? So if the website is defaced, means they put some other content, right, which is not related to what the company was doing, and therefore there is a huge reputational harm for this particular web defacing. So does this come under privacy? Right? Does this come under section 666C or D? Does it come under that? Any response that you see, Sham? Punishment for identity theft, punishment for cheating by using computer resources. Anybody is saying C or D?
One person said D, and C is what I think many people are telling.
Yeah. So C, because he hacked into supplier's account, and it is definitely hacking using computer systems and so on, and therefore it can be actually booked under C and D. But one difference that I want to tell you, right? Now, the defacing of the website, whose reputation is harmed? Is the director of this particular company whose reputation has been reduced, or is it the company itself whose reputation is lost? Is it the director's reputation which is lost, or the company's reputation which is lost? In the chat box, please.
Everybody seems to be telling company reputation.
Company. Okay, this is a very fine difference. Most of the privacy and data protection law, including the EU GDPR and our data protection bill, covers privacy harms to natural persons. Natural persons means like you and me, who are living, right? Even dead persons are not covered. Only living natural persons are covered. So business entities are not by privacy and data protection regulation. You understand? So this particular defacing of the website, which created privacy harm to the company, can never be taken to the court. Is that clear? Anybody in the chat? Clear or not? Any questions on this? Okay. So the privacy regulation throughout the world covers only privacy harms to natural persons. It does not cover the harm caused to a business entity or a legal entity. And therefore, this particular case, the defacing of the website causing reputational harm cannot be taken to the court. Is that clear? Next.
Somebody is asking why this case does not come under 66D.
66D. Punishment for cheating by using computer resources. It can also come because this is this is cheating, right? Cheating meaning that he is sending this mail as if it is originating from the supplier, asking for money and things like that. So, and if, for example, the director indeed pays 1 crore, assuming that it is for the supplier, then he has been cheated. So it can also come under section 66D as well, right? So normally, when these cases are filed, it is all covered under multiple clauses, not just one clause, right? So it is basically covered under both these clauses. Okay. 66E, violation of privacy. Basically, Information Technology Act, though it was conceived in 2000-2008, it had a section on privacy, specifically, but it is very narrow in scope, right? If you just see the those which are in red, right? It basically covers transmission of images of private area of any person without his or her consent. It's very, very, sort of narrow in scope, right? So this, we did not touch about it earlier, but if you look at Solovay's book, there is an attribute called exposure of person. I think we covered it. We covered it to some extent, I think. So exposure is the type of privacy harm which is created if someone intentionally or knowingly captures and publishes the image of private area of any persons. So this is explicitly covered in section 66E. And the case is one of the very infamous cases, right? So there was in Jawaharlal Nehru University, there was an MCA student who basically, got some inappropriate videos of his student colleague in Jawaharlal Nehru University. He made CDs and basically circulated to to many people, right? So he was booked under section 66E because he basically knowingly and intentionally violated disseminated the inappropriate form of this girl student, and therefore he was booked under section 66E. The case was in 2012, and it painted a very bad picture about the happenings in the campus of JNU, right? So this was a very infamous case which happened at Jawaharlal Nehru University, and he was booked under section 66E of the Information Technology Act. Okay. Section 66A. Now you must be wondering, why professor is talking about C, D, E and all without talking about A, right? So that question should have come into your mind. So let's see what section 66A means. So it says that any person who sends using computer resources grossly offensive or has a menacing character. Yeah. So sorry. So grossly offensive or has a menacing character, false information for the purpose of causing annoyance, right? Inconvenience, danger, insult, criminal intimidation, enmity, hatred, or ill will, or causing annoyance or inconvenience is punishable. What do you think about this particular clause? Is it too broad and covers everything on earth? Or it is very specific that it has to be, it is appropriate. How many of you think that it is not appropriate, right? Because it is so vague and so broad. And how many of you think that, oh, it should be there because it is very appropriate? In the chat box, what are you getting, Sham?
I think people are saying vague and broad. Parvati Jayaprakash seems to tell, and Prabha also seems to tell it is broad. So yeah, Palak.
See,
very broad.
You might think, yeah. So Sham might think that I'm very sort of, I am causing annoyance and inconvenience, right? But Professor Vivek may not. It's not subjective, right? What causes annoyance to me may not cause annoyance to the other guy. I think that cat is a very annoying creature, but my neighbor loves the cats, right? So there is nothing. So it is very difficult to sort of quantify this, and it is not omnibus. That doesn't apply to everyone, right? So which means that this is very broad in nature. Okay, the classic case is the Shreya Singhal case, right? So I don't know how many of you know about this particular case. How many of you know about Shreya Singhal case, which happened around 2015? In the chat box, please. Yes, sir. No, Sham?
Answer is no. I think majority seems to be no.
I have to explain the story, right? The story. So the story goes like this, right? In 2015, Mumbai, right? The then Shiv Sena leader, Sri Thakre, Bal Thakre, passed away. Okay, so the Maharashtra government basically declared a holiday. On the next day, it declared a holiday, right? State holiday. I think he was not one of the office bearers of the government, but he was just the leader, right? But still, given the fact that he has been there in Maharashtra politics for a long time, they declared the holiday. Okay, so whole Mumbai came to a standstill. I don't know how many of you live in Mumbai. Mumbai is the most vibrant city in the world. In the world, at 2 o'clock in the night, you can go in Mumbai. I lived in Mumbai for about 3-4 years, long time back though. But it is very safe. It's very, very safe, right, compared to other regions of the country. So one girl, in fact, wrote in her Facebook timeline that how can a city like Mumbai, city of Mumbai has about 20 million people, how can it come to a standstill because of the demise of this particular leader, right? It is unthinkable that a city of 20 million has come to a standstill. The next minute, her friend did a thumbs up on Facebook. The next day, these two girls were arrested by the Mumbai police, right, and taken to the court under Section 66A of the Information Technology Act. They said that whatever the girl posted and whatever the girl, did a thumbs up, approving that, caused or could have caused annoyance and anger, and then created communal unrest throughout the city of Mumbai. And therefore, under Section 66A, the post, that computer-related messages that they posted was very harmful to the society at large, and therefore they were apprehended. So at that time, there was a girl called Shreya Singhal who was doing her law at London School of, I think, one of these UK schools. And she was on a vacation here, and she learned about this in the newspapers, right? She was a lawyer. So she said that I'm going to take this one up, right? An expression, freedom of expression is protected under the Constitution. And if somebody says that, it is a very generic remark that she made, and it could not have been pointed to social unrest, and whatever the police did under Section 66A was incorrect. So she took up the case, filed the case in Supreme Court. Okay. So Supreme Court deliberated it quite a bit, 2 or 3. I think it went on for 6 to 7 months. And finally, the Supreme Court came up with this decision in 2015, saying that they quashed this particular Section 66A of the Information Technology Act. This is famously known as the Shreya Singhal and versus Union of India. She actually filed a case against Union of India, right? So she basically fought against the Information Technology Act provision of the 66A Act. So famously known as Shreyas Singhal case. It was quashed. The section 66A was repealed and quashed by the Supreme Court, and the section restrains freedom of speech and hence intrusion of privacy. So under the Constitution, freedom of speech and intrusion of privacy, the privacy are guaranteed for the individuals, and therefore any intrusion of that or restraining of the freedom of speech would not come under the Constitution of India, and therefore this particular section was repealed by the court in 2015. Right? That's why I did not talk about 66A, but directly jumped on to C, D, and B is okay. It's not very relevant, right? So that's why I did not discuss B. But this is the history of section 66A. But believe me or not, after the repeal of this particular section in 2015, police have been arresting left and right individuals under section 66A as late as 2022. So recently, if you look at the newspapers, 2 or 3 months back, the Supreme Court again issued a note to all the police and judiciary saying that there is no clause called 66A. It has repealed a long time back in 2015, and therefore the police can no longer arrest a person under section 66A of the Information Technology Act. That's the story of 66A. Any questions on this?
There are a couple of questions.
Yeah.
One question by Siddhartha Lal, he says, did they quash the section because they wanted to uphold freedom of speech or individual privacy?
Okay, so there are two things, Siddharth. Okay, so one is, of course, the freedom of speech is guaranteed under Constitution of India. So anything, I mean, it is not a blanket statement under the Constitution of India. If the freedom of speech is not honored, if the freedom of speech results in real social unrest, or it is in the not in the interest of the national security, things like that, and if it can be proven, then the freedom of speech should be curtailed. It is not a blanket free-for-all thing that is given by the Constitution, right? However, the section 66A is too broad to include everything under the 66A, right? And the Supreme Court basically looked at the very broad nature of 66A, which, because of that, intruded into restraining the freedom of speech as well as the privacy of the individuals. Now, what is privacy of the individuals? See, I should say whatever I want, right? If I'm constrained not to tell about it, then there is some inhibition in me, and that is not a voluntary expression, and therefore that could be conceived as intrusion of my privacy boundaries. So freedom of speech is also closely related to privacy, right? If I'm not able to do whatever I want, then it is a curtailment of my freedom, and it intrudes into my privacy boundaries not to tell something that I really wanted to tell. Does that answer your question, Sridhar?
Another question, or maybe a pointer that Gajanan Patil says, the recent case of Ketki Chitale, he's referring to one case. I don't know.
I'm not sure. I'm not sure. Okay. So we'll take it up later. Probably you can ask him to explain that. Okay.
Okay.
So that's yeah.
One more small point before we move.
Yeah.
Is the punishment same for children and adults? Is what Dr. Shravani is asking.
See, we do not have any law which is directly applicable to minors, that is below the age of 18. Okay, all the laws are applicable for adults, only for adults, adult natural persons. Okay, so the minors, that is below the age of 18, I cannot 100% say that they cannot be booked under the Information Technology Act. I cannot 100%, I'm not 100% sure, but it's a very good question. But it has to be taken up under Indian Penal Code. That's my view. So let's proceed. So section 72 of the Information Technology Act is also related to privacy, as you can see here. It is related to breach of confidentiality. It is breach of confidentiality. We discussed it yesterday, right? So any confidential information that you give to your doctors or lawyers or your friends, if it is leaked in public, then it leads to breach of confidentiality and hence intrusion of privacy. Section 72 of the Information Technology Act clearly says that. What it says is that anybody has secured access to any electronic record, book, register, correspondence, whatever it is, without the consent of the person concerned, discloses it, right? Discloses it, shall be punished, right? So there is a secured access to computer and computer-related resources, including electronic records, books, registers, correspondence, information, messages, and so on. And somebody has accessed this, right, without the consent of the person, discloses it in public, then it is violation of privacy, right? It is exactly what we discussed in the last class, right? Breach of confidentiality. Somebody has given you secured access and you misuse it. Classic case is this. There was this company called Grape Consulting, right? It was doing a lot of research, it is basically a consulting company, right? And it is subscribed to a lot of research databases, okay, research databases. Now, this guy called Abhinav Goyal, who was the IT manager, he had secured access to this particular research database subscribed by Grape Consulting. All these research databases are very expensive. For example, if you want to subscribe to, for example, ProQuest, right? ProQuest is a business consulting database. It costs quite a bit. It's, I think, it costs something like 15 lakhs per year or something like that. It's quite expensive research databases. Now, what this guy did was, since he had secured access, he downloaded all the data and documents from the research database. He created his own consulting company and he sold it through that company to outside. So he was basically misusing his secured access to this research database, just declared it in public, for a fee, right? So he basically benefited, monetarily benefited by using the secured access. And Grape Consulting actually trusted Abhinav Goyal to keep all these passwords and things like that secure and the research database secure. But in fact, he misused it, right? So it's a very classic case where the secured access was misused and against the contractual norms. So this case could possibly come under Section 72 of the Information Technology Act because Abhinav Goyal did not get the consent from the managing director or CEO of the Grape Consulting. He had secured access to research database. He published all this information outside for monetary gain, and this could possibly be booked under this one. But a very interesting case is this. I don't know how many of you are from Maharashtra. How many of you are from Maharashtra? In the chat box, please. Anybody from Maharashtra? Shah? Nobody?
Oh, there are few people. Yeah, definitely. Many people.
Okay.
Yeah.
So there is, all of you from Maharashtra know about Kolhapur district, right? And Kolhapur is very famous for slippers, right? Kolhapur slipper is very world famous, in fact. But it is also infamous for one particular thing. And I'm not sure whether it still exists or not, right? But in 2012, this case dates back to 2012. So the Kolhapur district has the infamous notoriety for having a large number of radiological and imaging clinics. Okay, what happens? What happens is that most of the women who are pregnant basically go to Kolhapur, and because of the wide availability of scanning diagnostics companies, they scan the pre-birth scan. They do it, and then a lot of infanticides are noticed in the district of Kolhapur. Infanticides, genocide. So infanticides. So even before the child was born, was killed. So the district collector of Kolhapur, who took charge, he wanted to curb this, okay? Because infanticide is prohibited in India, and therefore he wanted to clear this, right? So what he said was, he instructed all the radiological and imaging clinics in Kolhapur that any sonogram of the pregnant woman taken should be uploaded into the district website. Okay, so they have each clinic was given the username password, and whenever the sonogram was taken, it had to be uploaded. So the objective was that the district government, the district headquarters, will have all the images in the sonograms, and if any infanticide is noticed, right? If it is noticed in the district, then it can be traced back to the originator, and that woman and the associated families could be taken to task for punishment, because infanticide is prohibited in India. Right? It was a very noble intention, but unfortunately, the Radiological and Imaging Association did not approve it. Right? So what it did was that it filed a case called Radiological and Imaging Association versus Union of India case in 2012. They said that this particular order from the district collector severely intrudes into the privacy of the pregnant woman. Right? Why should the district collector see the sonogram of a pregnant woman? Right? And it intrudes into the very privacy of the pregnant woman, and that this should be immediately revoked. The order should be revoked. Okay, Supreme Court listened to that, and you can tell me what the verdict is in the chat box, please. Was the order revoked, or was the district collector allowed to do whatever he wanted to do? In the chat box, what's the conclusion? Shyam?
Revoked.
The order was revoked. Supreme Court unanimously said that it comes under section 72 of the Information Technology Act, because no consent was taken from the individual, right? The consent was not taken. All the sonograms without consent should be uploaded in district collector's website, right? And it is disclosed to the district collector, because the district collector can have access to that, right? So it comes under the invasion of privacy of the individual, and that it should be revoked. Okay, even though it was a noble intention. So you can see that even noble intentions can cause severe privacy harms. In which case, you must be hearing about this Roe versus Wade case in the U.S. Supreme Court, right? So the Roe versus Wade case, long time back, Supreme Court announced that abortion is legal, right? But today, because the infanticide, because of the fact that infanticide is taking place, the Supreme Court has reverted the decision, saying that abortion is illegal, right? So, but now again, Biden administration is arguing that the decision to not to abort should be left to the individual woman, and that is her privacy rights, and so on. So it's going on, right? So this is associated with privacy. I'm not saying that it's exactly related to privacy, but this particular case is definitely an invasion of privacy, and the Supreme Court, long time back in 2012, revoked the order. Okay. Section 72A, I'll just mention it briefly, imposes penalty, including an intermediary who's obtained personal information while providing services under a lawful contract, discloses the personal information without the consent of any person, and so on, right? Unauthorized disclosure to a third party. So, for example, Google search, if it collects the information about your browsing history and then passes the keyword along with the browsing history to an intermediary without obtaining your personal consent, and discloses it to the third party, then it could possibly come under section 72A of the Information Technology and can be punished. Okay, so that's one of the reasons why, for example, we have all these conditions, right? The consent agreement that are put in by companies. Okay? So that's 72A, which is an offshoot of 72. So we'll come back to that. Now, having discussed about this intermediary, we need to delve into some details of this intermediary. Now, slowly we are coming into the ambit of social media companies, search companies, and so on, right? So section 72A is related to the information that is collected by an intermediary and discloses it without the consent of the person to outside or to a third party, right? So what is an intermediary? And this intermediary is covered in section 79 of the Information Technology Act. So this is the definition of the intermediary. What is an intermediary? It connects person 1 to person 2, right? But it doesn't do certain things. What does it do? It doesn't initiate the transmission. The intermediary does not initiate the transmission. It doesn't select the receiver of the transmission. It does not select or modify the information contained in the transmission. Then only it can be called as an intermediary. So tell me whether WhatsApp is an intermediary as per this particular definition. Yes or no? WhatsApp is an intermediary. Yes or no? What is the answer?
The answer is yes.
Yes.
Right? Yes.
Because in WhatsApp doesn't initiate the transmission. You or me, person 1 or person 2 initiates the transmission. WhatsApp doesn't select the receiver, right? You decide whom you want to send a message to, person 2 or group 2, right? WhatsApp does not select or modify the information contained in the transmission. It transmits. In fact, WhatsApp boasts that it does not even know what messages person 1 is sending to message 2, even though it is a platform, because it says that end-to-end encryption is being provided. Therefore, only person 2 knows what person 1 is saying. I myself, as a WhatsApp intermediary, I myself don't know what is, and therefore it has no chance of selecting or modifying the information that is sent between person 1 and person 2. So WhatsApp or any other social media intermediary. So for example, Gmail, does it satisfy the intermediary condition? Yes or no? Is it an intermediary, Gmail? What's the answer you're getting?
There is one no and there is one yes.
Why no? I want to know why he says no.
There are a couple of people saying no, actually.
Okay, so open up one of those and then ask them to explain.
Yeah, the last person who said no was, okay, Palak Tandon. I'm going to ask him.
Yeah.
1 second. Yeah.
So
Palak, I have, Palak, you have said no. Is there a reason why you have said no? You can unmute and talk about that.
Yes.
Or there's another person, Piyush Gupta, who has said no. I can enable him. Give me 1 moment. Sorry. Yeah, Piyush Gupta. Piyush, I have, yeah. Can you talk about the reason as to why you have said no? You can unmute yourself and talk about. Professor, maybe you want to continue.
Yeah, I think I'll continue. Yeah. See, Gmail, if you see, Gmail, you are, you or me are sending the initiating the transmission. We select, to the address book or whatever it is, who has to see the transmission, and we do not modify the content, which is, Gmail does not modify. We actually construct it and send it. It is passed as it is by Gmail. And therefore, most of these instant messaging, even for example, telephone companies, when I initiate the transmission, I pick up a call and talk to Sham, right? So I select the receiver, I initiate the transmission, and when I talk, nobody is modifying or disrupting that call, right? The telecom company which is carrying, Airtel or Vodafone or whatever it is, it's not modifying the content of the transmission. Therefore, all these qualify as intermediaries. In fact, there is a whole host of companies like telecom service providers, as I discussed before, network service providers, internet service providers, like what I discussed, web hosting, search engines, online payment sites, all these things come under the definition of intermediary. And what this particular section 79 says is that the intermediary shall not be liable for any third party information, data, communication link hosted by him or her. In fact, this says him. Very, very male chauvinistic writing of the section 79. So what it means is that none of these intermediaries are liable for any third-party content under section 79 of the Information Technology Act. This is called as indemnity rule. All the intermediaries are indemned, right? They are condoned. They are, even if, for example, false information goes through it, or some inflammatory information goes through this intermediaries, the intermediaries shall not be liable. That is the rule which was written way back in 2000, modified in 2008 under section 79. The reasons are manifold. It was at that time that intermediaries like platforms were coming up, and we did not want to curb the growth of innovation in digital intermediaries. Right? Most of all these are intermediaries, right? So we did not want to create stifle the innovation, and therefore intermediaries were indemned for any liability for third-party content until now. We'll come to that later on, right? So in section 2008, we introduced this particular clause which says that the intermediary observe due diligence with respect to being an intermediary. So we just put this particular clause, but there is no indemnity. There is no indemnity. So how many of you think that intermediaries should be liable for third-party content? Yes or no? Intermediary should be liable for third-party content. How many of you say yes? And how many of you say
I think there are many no's.
Many no's. So you and I agree. And the law says that, right? An intermediary is just an intermediary. And therefore, they should not be responsible for any third-party content, right? And that's the way in which the rules have been framed. This is a very interesting case, right? In 2009, this case is called Google India versus Visakha Industries, intermediary liability. So what happened was that there was this company called Visakha Industries, and there is also an institution called Ban Asbestos Network India Limited, or BANI, whose coordinator was Mr. Gopal Krishna. So this Gopal Krishna had a blog site, a Google blog site. In that blog, he wrote saying that this Visakha Industries is producing asbestos, and it is selling asbestos to all low-income families for construction of their homes. Okay, as you know, under the Environmental Protection Act, use of asbestos as a construction material is prohibited in India by law, by the Environmental Protection Agency. So Visakha, so he said that this guy called Gopal Krishna, he had some knowledge or something like that. So he wrote it in the Google blog saying that Visakha Industries is violating this Environmental Protection Act, and it is producing asbestos and selling asbestos in India. Okay. So Visakha Industries immediately responded saying that, no, we are not doing that. Okay. So we are not manufacturing any asbestos. This is a false information, which was posted by Mr. Gopal Krishna on Google website. So instead of suing Gopal Krishna, because Gopal Krishna is an ordinary individual, Aam Aadmi, it sued Google. Okay. Why it sued Google? It sued Google saying that Google hosted the website of Gopal Krishna, the blog site of Gopal Krishna, and the information that was contained in that particular blog was absolutely wrong. It is misinformation. And Google, which hosted that, should have taken responsibility, should make sure that the information which is posted on its blog site is legitimate and genuine, and it could not be false. And therefore, I'm suing Google India. So what do you think is the merit of the case? In the chat box, please. Who won? Google India or Visakha Industries? Google India or Visakha Industries? GI or VI?
Google is what people are saying.
Google. In fact, Google India won this particular case. Why? Because it says that, oh, I'm an intermediary, right? Somebody, third party like Gopal Krishna, posted the information about another third party, which is Visakha Industries. I don't have any liability. I am immune under this act. Section 17 intermediary rules. I shall not be liable for any third party information. And therefore, Visakha Industries cannot really sue me because I am protected under the intermediary liability clause. Okay. So, This happened a long time back in 2009, right? And that's when intermediary liability actually came into being questioned in India. Okay. Now, how many of you tell me now that intermediaries should be liable for third-party information? Have you changed your opinion or not in the chat box? Should be liable, yes. Should not be liable, no. It's a very big question. No is the answer.
No is the answer.
Okay, okay, fine. So, what happened? A lot of things have happened since 2009, right? So it was just a blog, whereas today we have instant messaging, posting, social media intermediaries, Instagram, and all those things. They're all intermediaries, and people are posting messages left and right, right? And you know this cow slaughter case where a message went through a particular WhatsApp group, and there was some, group riot which took place in particular areas in UP or Rajasthan, one of those places. A lot of things are happening today as we speak, right? So, for example, the Nupur Sharma case. You must be following about the Nupur Sharma case. Somebody posted in social media the Kanai, the tailor, and he was murdered, and so on. So today, the misinformation, fake information, false information, or the information that is causing social unrest has gone beyond the limits of these, the small messages and posts. It can have wide repercussions. So we basically looked at the Information Technology Act, and we introduced, the government of India introduced certain guidelines for intermediaries and digital media ethics code in 2021. It was released in February of 2021. So what it said was, I'll come to that later on. What does this intermediary rule say? It says that the intermediaries should observe due diligence. What is due diligence? Due diligence means that they have to be vigilant of messages which are going through the platform and take corrective actions as and when required. Apart from that, they have to appoint a chief compliance officer who will basically look at compliance to Indian laws and regulations. They will also apply a nodal person for coordination with the law enforcement agencies. If the law enforcement agencies want certain information, then the intermediary should be able to give it to them. They also should have a resident grievance officer, right? So all these things were posted as part of the intermediary rules. They also said that the intermediary shall deploy a technology-based measures, including automated tools or other mechanisms to proactively, this is very important, to proactively identify information that depicts whatever it is, some things, okay? So all these were included in the revised rules. Okay. It also said that a significant social media intermediary providing services should enable the identification of the first originator of the information on its compute resources as may be required by judicial order. Okay. So the complete indemnity was removed. They have to do some due diligence. They have to take technology-based measures to proactively identify certain false information or obscene information. They also should enable the identification of the first originator of the messages, because the messages can go forward, and so on. But you should be able to find out who the first originator of the messages, right? So, of course, Twitter and Google, WhatsApp, Facebook, they all did not like this, right? In fact, they're all global companies. They are not regulated by Indian laws and regulations. They did not have any chief compliance officer or residence grievance officer, and therefore they resisted. But in government of India put down its foot. Then you know that Twitter was in a pretty bad shape because they did not have the chief, resident officer, and police in fact went to the office where the Twitter board was there, and then the board arrest board was inside, and so on. It went up to that extent, right? And finally, Twitter also complied along with Google and Facebook to appoint all these officers so that it can comply with the law of the land. But this particular clause is very, very intriguing, right? These two clauses, right? Now, if the intermediary wants to proactively identify the information, will it impinge on the privacy of the individuals? In the chat box, please. Yes or no? If it has to proactively identify information? Will it impinge on the privacy of the individuals? In the chat box?
The answer is yes.
Yes. How do you do proactive measuring, right? If you want to do proactive, then that means that you have to see all the messages and then you have to classify, right? Now, some things may be classified under this particular clause, but most of them, 99% of them, will not fall under this particular clause. But you have seen them. The fact that you have seen them intrudes into the privacy of the individuals. So that is a very important caveat of this particular clause, right? So if you use these mechanisms, then it is possible that you will see messages otherwise you would not have seen, right? Which intrudes into the privacy of the individuals. The second one, this is also very important. First originator of the information, right? So we get a message, we forward to group, forward, and so on, right? You really don't know who the originator of the message is. And that's the beauty of WhatsApp, right? So WhatsApp says that it is end-to-end encryption. End-to-end encryption. The whole message is encrypted, right from the header until the footer. So which means that even the originator of the message is encrypted, right? Using session keys. So which means that only the recipient will be able to use the session key in order to decrypt that. Of course, Professor Sridhar and others must have discussed about it quite a bit. So without the session key, it's not possible for me to actually decrypt this. And this session key is temporal and it is just specific for that particular conversation, which has happened between person 1 and person 2. And therefore, WhatsApp is saying that I myself do not have the key in order to decrypt this. How can I find out who the originator of the message is? So this is to protect the individual's privacy, right? On the other hand, the government says that if you don't give me the originator of the information, and if some misinformation spreads through like wildfire, I should have some control over the person who has originated. I want to apprehend him, right? But then you have to actually decrypt and give me that particular originator of the information. So there is a conflict, right? There's a conflict between the security of the nation, social security and so on, versus the privacy of the individuals. And there's a thin line which separates between these two. And this is a bone of contention with all the intermediaries with the government of India. The cases are still going on, right? So for example, the recent case by Twitter, who filed the case in Karnataka High Court against the Union of India for taking down certain posts because it says that violates the freedom of expression and privacy of the individuals, right? So these are all some amendments that we have made, but this is tricky. It's tricky, right? Anyone who has any comment on this particular clause in the chat box, please? Anything, Shyam, you can say? No?
Not yet.
Okay, fine, no problem, right? So these are all the Information Technology Act. So even though Information Technology Act is very old, right, 2000, amended in 2008, and now the rules come into place 2021. In fact, some new rules, which are refinements of these intermediary rules, are going to be published soon by the Ministry of Electronics and Information Technology, especially with respect to intermediaries. Okay. Privacy and data protection. So we'll just check. I mean, all these things, most of it we discussed about it. I will some of these things we have discussed as well. I'll just go to the regulations first of all, right? Now, the regulations, most of the data protection regulation are about natural persons that I discussed earlier, right? So it does not cover business entities or legal entities. That is one of the important points that you have to remember. Okay. The second one is the data fiduciaries, right? The data fiduciaries or the companies which collect personal information from the data subjects have to adhere to certain obligations under the regulations, right? This is a summary from the European Union General Data Protection Regulation, which you can read. You should actually read. If you're interested, you should download it from the website and read that. It's not very long, it's about 28, 30 pages. But the principles are that there are some obligations of the data fiduciaries. They have to protect the data about personal, natural persons by design, right? So they have to limit exposure of this information. They should limit access. They should do data minimization. You should not store more than whatever data that you need. right? And all those things have to be implemented by the internet companies or data fiduciaries. That's called a privacy by design or data protection by design. They also have to keep track of all the processings, right? They should have logs and monitors and so on, and maintain audit trails so that in case the government or the state requires particular information, they can give it. If there is a privacy violation, they can also trace it back. They can be traced back, and therefore there has to be a log. They have to embed security in processing, right? So they have to embed security in processing, which means that they have to apply all the cryptographic techniques, security measures, access control mechanisms, and all the data that is stored so that the information is protected and not divulged in public or to third parties. They also have to adhere to this notification of any data breach. If there is any data breach and the private information of the individuals are leaked out, they have to inform immediately. In fact, even in India, it holds good. If the data protection bill is enacted, within 72 hours, the data fiduciaries whose data has been breached has to be reported to the data protection authority. And also it should inform all the users that, we are sorry, there is a data breach. It's possible that your personal information has been leaked, right? And they should implement methods so that this kind of breaches do not occur in the future. They have to basically take up all the measures to protect your personal information from all others. They also have to have data protection impact assessment periodically to make sure that their systems are in tune with data protection, and they are the overall health, data security and protection health of their information technology systems are properly monitored and measured, assessed. Okay, so all these are obligations of the data control system. This is called due diligence, right? In the intermediaries, if you go back to the clause, the data fiduciaries or intermediaries should take all due diligence. Due diligence means this, right? They have to have data protection or privacy by design. They have to have security in processing and so on. So all the techniques that we discussed, that Professor Vivek Srinivasan and Professor Sridhar discussed about cryptography and things like that should be implemented by the data fiduciaries so that the data breaches cannot, or at least minimized, right? So that is one of the important things of all the data protection regulation. There are some cases, right? There is a very important and very funny case, Google versus Vidal Hall case, right? So what did, you know that Google plants cookies, right? And for all the websites do plant cookies, right? So, suddenly we are saying that, oh, the companies are really, want to know whether we want to enable cookies or not, right? So we have this message saying that, accept cookies or not accept cookies. We also have some nuances, right? Accept cookies, or only when you are visiting this particular site, or permanently, right? So there are also cookies which are sort of session cookies, right? So which are used only for storing the information for that particular session. After the session ends, the cookie information deleted. Cookie is very powerful, right? Because cookie contains all the personal information, your browsing history, your passwords, for example, and things like that, right? And why do why do the websites plant cookies? Because it is easier for you to navigate. Next time you visit the website, you don't have to remember the username because the username is already picked up from the cookie. But it also is a violation of privacy, right? If you don't want the username to be known to the website, then you might disable the cookies, right? Or you might delete the cookies, or you might say that the cookie should be valid only for that particular session duration, and so on. Now, in this particular case, Google planted cookies when the data subject, Vidal Hall, browsed the website in its app Safari browser, right? So cookies collected personal browsing information and which is used to deliver personalized advertisements. We all know that, right? So Google, in fact, earns close to 90% of its revenue through personalized advertisements. How does it personalize the advertisements? Only through the information that is shared with using when you are browsing the websites, right? So knows your search words and knows your intentions to some extent, has created a digital person of you, all the browsing histories, and using the browsing histories and tailors the advertisements for you. So this particular person filed a case against Google saying that without my consent, cookies were planted and my personal browsing history was collected by Google in order to deliver personalized advertisements. It's a violation of privacy. I did not give consent to planting cookies, and this case was filed in the, I think it's in Spain, Spanish court or something like that, and Google lost the case, right? Because they did not inform Vidal Hall that a cookie will be planted to get access to the personalized browsing history. There was also another famous case in Spain where, you know, this guy called Mario Gonzalez. He had a house, but he was forced to sell the property to government because he owed a lot of tax to the government, and therefore government basically appropriated the house from him, right? Now, before appropriating this particular property, the government put out an advertisement in the newspapers, right? Now, Google, as you know, Google is an aggregator. So when somebody searched for Gonzalez, then they would get the advertisement, right? They would get the advertisement because the advertisement was for the house, which was put on sale by the government by, and it was owned previously by Gonzalez. Now, Gonzalez, after the case was over and his property was gone, it was taken over by the government. So the deal was over. So Gonzalez said that I have, under the EU General Data Protection Regulation, a right to forget, right to be forgotten. Because when people searched for my name, then this particular advertisement came, the search, right? Which was really bad for me because that advertisement said sale, forced sale of the property of Gonzalez, right? So, which is not a voluntary sale, it was a forced sale, which meant that he had done something wrong and that this property was amortized. And therefore, he did not want that particular advertisement to come up when someone searched for Gonzalez in the Google search bar, right? So he invoked the right to be forgotten, said that all linkages between his name and the property sale notification be removed. Okay. So Google, on the other hand, said that, you know, we are intermediaries. We are just showing the link to the advertisement. We are not actually showing you the advertisement, and this we are we should be protected under the indemnity. I mean, of, you know, for example, as a third-party service provider. But in fact, this case went against Google. Google was asked to remove all links, not only showing the messages, but all links to the property that Gonzalez owned, because he invoked the right to be forgotten. So most of the data protection regulations have this very, very powerful clause called right to be forgotten. So if, for example, if you're part of, you know, if you've been buying something from Flipkart, right, you have given a lot of information to Flipkart, including your personal mobile number and all those things at the time of registration. Flipkart knows what are the items that you have purchased. That's one of the reasons why you keep getting, when you browse the Flipkart website, the recommended products are shown, right? Because it knows your purchase history and so on. It has all your orders, you know, it has all the items that you put in the shopping cart, what you removed from the shopping cart, what you put in the wishing list, all this information is stored. But tomorrow you decide that you don't want to subscribe to Flipkart, okay? For some reason. Can you ask Flipkart that you forget about me? In the chat box, please. Yes or no? Can you ask Flipkart to forget about me? Forget means just forget. All the information about me should be just erased. Is it possible? Have you invoked it? We don't have a law yet today, right, to invoke it. But if the law comes into picture, yeah.
Brian Roberts says we can ask, they won't do.
They won't do.
There are a few no's, because the terms and conditions were initially agreed to and things like that.
So have you read the privacy policy of Flipkart? Does it say that if you deregister, we will continue to keep the information, or they will keep it, we will keep it for 6 months, we'll keep it for 6 years, we'll keep it for 60 years. Does it say anything in the privacy policy of Google? How many of you have looked at privacy policy of Flipkart or any of the privacy policies? Anybody who has looked at the privacy policy of any of these companies? Google, Amazon, Flipkart, anyone, Swiggy?
Yeah, I think many of the people say no, and then they make it too difficult to read. So
right. So that is a problem, right? All of them should have privacy policies by law, right? At least, even though we don't have law, at least if they have to abide by European Union and things like that, they have to have law. They have to have privacy policy. In the privacy policies, they state something, right? Normally, they say that after you deregister, we'll keep it for 6 months or something like that. But how are you sure that after 6 months it will be deleted, right? If you get an advertisement from Google, Flipkart, after 6 months of deregistering, then they are still using that information. No, only law can protect you. Only by law that, for example, this particular case where Gonzalez asked or invoked the right to be forgotten is possible only if you have law. And therefore, laws or laws and regulations are very important to protect you and me, right? Not the companies, but at least you and me. And that's why all the privacy and data protection regulations are written for natural persons like you. Okay, so that's more or less, I have just given you the gist of the various cases that have come under the privacy and data protection regulation. But the floor, it's about 54, about 6 minutes more. If you have any questions, you can ask me. I'll open the floor. Shyam?
Sir, there was one question early in the talk. I will read it out.
Yeah.
That was from Arun Tanksali. He says, do these laws implicitly prevent small services from being viable, as the burden of compliance can be very high? Is this concentration of power in large organizations an unavoidable side effect of such regulations?
Good point. So that's why we have defined in our intermediary rules a different requirements for significant social media intermediaries, right? So if you look at this particular clause, see, there is something called as significant social media intermediaries. So there's something called a significant social media intermediaries, right? Only these are asked to do certain things, right? A non-significant ones need not do that. The threshold in India is 50 lakhs. So if you exceed 5 million or 50 lakhs users, then it is referred to as the significant social media intermediary. In fact, when this particular intermediary rules came into picture in February 2021, this messaging app called Koo? How many of you know about Koo? In the chat box, please. Many of them know? Koo.
Yeah, people seem to know.
That's right. So Koo was not a significant social media intermediary at that time, because it had less than 5 million or 50 lakh subscribers. So it did not have to really comply with the identification of the first originator clause. So it is primarily addressed towards startups, right? So if you're a startup, you're just growing up, small company, then you don't have to comply with that rules and regulations, right? But once you become big, right? Once you acquire certain threshold number of subscribers or whatever it is, then you need to comply with it. So this is exactly to prevent small and medium prices to be stifled for compliance. By compliance. That answer your question? Any other questions?
There was one question. Is there any law to sue the callers by companies like providing loan, credit, credit card, etc.?
Yeah, if you, see, there you have to prove that they have created a computer-related offense. Okay, so either by cheating, impersonation, or hacking, got secured access to your information and disclosed it. If any of these things are valid, you can file it under any of the Information Technology Act rules. Okay, the only thing is that if you're right? Since the omnibus privacy bill is still pending, unless it is covered under any of the Information Technology Act rules that I have discussed, it may not be possible to file this. Yeah. So, for example, if you get a ransomware, right? If you get a ransomware, can I sue that company? I mean, if you find out who the ransom, see, let me tell you another truth, right? So I've been working with this cyber police of Karnataka for quite some time. In fact, there are thousands and thousands of cases, cyber-related cases, which are pending in the cyber police stations, okay, throughout the country. Not only for Karnataka, it's for everywhere. The reason is that most of these crimes happen on intermediaries. Okay, so for example, you get a ransomware from Nigeria, okay, and you clicked on that, you lost about 1 lakh rupees. Where will you sue? Right? How will you sue? You first go and file the FIR at the cyber police station, right? Now, so they have taken your FIR. Now they have to find out who the originator of the crime is. Okay, so they have to go to Google. They have to go to Google. If it is Gmail, they will go to Google, and then they will ask to find out who the intermediary is. Now, Google has to, because it's a significant social media intermediary, and if it has to identify the first originator according to the intermediary rules, they will promptly say that this guy is, ABC at Nigeria, who has originated this information. Now, the Karnataka police or the MP police do not have the jurisdiction to arrest someone in Nigeria, right? It's a big problem. Right? He is staying outside the country. So how will they do that? There are some inter-country security alliances. There are countries which have teamed up, said that they will all collaborate and help each other with respect to cybercrime. So they have to issue a warrant against this particular ABC in Nigeria through this particular treaty. Okay. Now this will take another 2 or 3 years before it reaches Nigeria, and the Nigeria police finds out who the culprit is. So time is wasted and nothing comes out. So 95% of the cyber cases are yet to be solved by our cyber police because of this. Because the cyber crime is global in nature, and unless we have a very suitable global policy for arresting cyber crime, it is not possible to find out the first originator and arrest him because of the jurisdictional limitations. Right? So if it is in India, for example, that recently there was a big call center guys who have been arrested, right, in Bangalore, because they were cheating customers using Amazon gift voucher account and things like that. So if it is in India, they can do it, but if it is outside India, then it is very difficult to get the crime solved because of this inter-country jurisdictional issues. Does that answer this question?
Professor, I have one question.
Yeah, go ahead, please.
Yeah, so actually my question is related to the calls, like advertisement calls that we get.
Correct.
Like they wanted to sell, the credit card or sometimes loans. So it's like, even though we say we don't want, I'm just wondering, like, because this data, who is sharing our personal data, like phone number and all? So can we sue the caller, or is there any law?
Madam, have you used do not call registry?
Yeah, but somehow they get.
So we have a mechanism. I mean, as you are probably aware, these are called as intrusive calls, right? So which also violates the privacy and also has a lot of repercussions. So the Telecom Regulatory Authority of India, through the commercial protection regulations, have enabled this do not call registry. So it is possible that you can go to do not call registry, put your phone number, and then allow only certain types of calls or messages to reach you. But people are violating this left and right. You have correctly pointed out that you are because there is a commercial interest both for the telecom service providers to allow the call and the digital advertisement companies to make the calls, and therefore this has been very unsuitable. So now again intermediary picture comes into picture. Whom do you sue, right? So do you sue the telephone company because it has allowed these calls to get through, even though you have registered under do not call registry? No, because again they will say that we are intermediary and therefore we are indemnified. So it is a very difficult situation. So as I have heard last, I was working with TRIA on this particular project, and so they are going to implement some kind of blockchain-based registry mechanism through which you will be able to actually find out who the originator of this particular call. Because these originators of the calls, they use different numbers, different SIMs. They have 10,000 SIMs and things like that. Right? It is possible to do that. We have also included recently KYC-based verification for caller ID authentication. Right? So whenever you receive the number, then that number will be checked in the KYC database, and the name of that individual or a person associated with that KYC document will be published, will be known to you. So through this, you can actually find out which company is making these calls, and you can sue that. You understand, madam? So these are all the mechanisms that we are trying to implement so that the consumer grievances reduce as much reduced. So tomorrow, once the KOC based caller ID identification comes up, everybody will get a caller ID, right? Not just using Truecaller, because I'm now getting the same call. So you will get the ID, and therefore from that you can figure it out. Suppose, for example, it is coming from a real estate company, and you have said no in the do not call registry for any real estate calls, and if you get that, you know the name of the company, and you can actually file a complaint with the regulator.
Umakant Panda says, I have lost a pen drive. If somebody gets it, and if it is misused, can that attract any of the sections?
See, if, for example, the pen drive is protected through a password, okay, it has a secured access, and then the person hacked it to gain access to the pen drive documents, yes. Okay, otherwise, no, because it is not that it was given to him as a trusted individual, because you just lost it in a public place. So somebody took it, right? And somebody took it, and therefore it was not, it is not a breach of confidentiality. And therefore that information is posted in public or whatever it is, unless it satisfies the other requirements. So for example, if it is, exposure of private persons or the individuals or whatever it is, then it can be sued under different sections, but not for, but if it is, for example, if it is secure, protected using password, and the person who took that hacked into it, then it is a computer related offense. So it has to be related to one of these computer related offenses. Just by taking it and using it, you cannot really do much about it, because it is not, it is just lost in public place. Does that answer your question?
Sir, one last question for the day, if you are okay.
Yeah.
If Google, this is from Jayasurya, he's asking if Google shares our email ID or other personal information to global companies for their advertisement, is it an offense under Indian law or not?
See, you have to look at their privacy protection, right? So have you looked at, any of you looked at the privacy settings? In the privacy settings in Google Chrome or Gmail, go to the privacy settings and then check what you have allowed the intermediary to take. Okay, so you can fine tune that. In fact, there are tools available which will basically check how, what your privacy settings are, how your privacy settings are. So if you prohibit, for example, cookie setting, then cookies cannot be implanted on your machine, right? So it is quite possible that the functionality of the website may not be good because the cookies are not being set. Those are all the trade-offs that everyone has to make. In the fine print, Google says that the browsing history will be made available to the third-party agencies in order to provide personalized advertisements, right? And these browsing histories are taken through cookies. So if you allow cookies to be planted, then you are consenting that whatever is there in the cookies will probably be shared with the third-party agencies for advertisement purposes. So you have to go to the privacy setting. If you disable cookies, right, then that personal browsing history cannot be captured by Google, and therefore you will be protected. Unless you do that, you are governed by the contractual clause in which you have agreed to allow for cookie settings, and therefore you cannot really file a case against Google for taking your privacy history and sharing it to third parties. Hope that answers your question. So go and look at your privacy settings and then set it appropriately. Okay, Shah, is that okay?
Okay, sir.
Yeah.
Yeah, sir. Thank you very much. This was a fantastic talk, and then I think both the talks were really very nice. And thank you very much for your valuable time. 2 sessions. I think it is very hard, but it was fantastic. Thank you very much, sir, from on behalf of all of us, as well as the summer school people. Thank you.
Yeah, thank you, Professor Sridhar, for an excellent session. I'm sure there's already request for your future MOOC course on data privacy.
Thank you. We'll hope to see. Yeah. Thank you very much, Professor Vivek. Yeah, thanks for inviting me.
Thanks a lot. Thanks
all.
all.
Wish you all the very best.
Sure. So tomorrow at 10, we have a session from Professor Ashish Chaudhary on multi-party computation. I'm sure it's going to be an excellent talk. So I look forward to see you all tomorrow at 10. And thank you, Shyam and Annapurna, for very diligently coordinating today's and yesterday's session. Yeah, thank you.